to him over the airwaves, but they were very concerned about what in fact did happen, which was that there would be violent reaction in the Islamic world to this provocative act, this stunt that Jones put on. In fact, there was a demonstration in Afghanistan where 9 people were killed and 81 injured protesting the burning of the Quran. Jones says, it was intended to stir the pot. If you don't shake the boat, everyone will stay in their complacency. In that great tradition of First Amendment weirdoism. So unquestionably, he had a right to do that under the cases starting with Stromberg. And then other kinds of subversive or discomfiting speech that have come up that are landmarks include Cohen versus California, the fuck the draft case. That's the one where Cohen had a jacket, since Vietnam War days, 1971. He had a jacket that had fuck the draft embroidered on it, and he wore it to the courthouse in Los Angeles County. And a police officer noticed it and was alarmed, horrified that somebody would do this, and followed him into a courtroom. Where he took off the jacket when he went to the courtroom, folded over his arm, so it wasn't visible. But the police officer went up to the judge and said, "The guy over there has got a jacket on that says fuck the draft, and you ought to hold him in contempt of court, wearing it in his courthouse." The judge refused to do that. There was no disruption in the courtroom. There was no disruption in the halls of the courthouse where he had his jacket on. And Cohen was arrested by the police officer under the California disturbing the peace law. It's an old common law concept that people can't disturb the peace, and you can imagine all kinds of situations in which disturbing the peace should be punished. And here the California law prohibited willfully disturbing the peace or quiet of any neighborhood or person by offensive conduct. And Cohen was convicted of violating the disturbing the peace law and sentenced to 30 days in jail. And the case went to the Supreme Court. When the case came up for argument in the court, the Chief Justice at the time was Warren Burger, who we met before briefly, we'll meet again, who was a very uptight, sort of prudish, decorum-oriented man. And before the lawyer for Cohen started his argument, Chief Justice Burger said to him in open court, "The court is well aware of the facts of this case, and it will not be necessary for you to go into the fact thing." Basically, the subtext is, don't say fucking open court in the Supreme Court of the United States. We don't need to hear that. And so, to his everlasting credit, the lawyer got up and said, in his opening argument, he says, "My client was arrested in the Los Angeles courthouse for wearing a jacket that said fuck the draft." And went on to make his argument. It was exactly the right thing to do. And probably not because of that tactic, but because of his arguments, the court ruled 5-4 in Cohen's favor. And the decision was written by Justice John Marshall Harlan, who it was a surprising decision. It was an elegant decision. Harlan was a very conservative Republican, a judicial conservative in the very best tradition, intellectually rigorous, but who insisted on not deciding cases that they didn't have. He would be horrified by what the court did in Citizens United. He's long dead. But he would have been horrified because it was such a judicially activist thing to do. He was a true principled judicial conservative, and he wrote the opinion for the court. And the Harlan opinion illustrates some important First Amendment points. The court's First Amendment analysis was not really well settled back at the time of the decision. The formulas about strict scrutiny and compelling government interest and all of that were not yet embedded in the court's approach. But Justice Harlan made some interesting First Amendment points that still stick with us. He notes, for example, that while Cohen didn't say anything, didn't open his lips, his conduct was treated as speech protected by the First Amendment, as in the case of Yetta Stromberg, Long Now, and so on. Then the question is whether this is a valid time, place, and manner regulation. And in 1971, even that notion was not well recognized yet. The notion is this: the government cannot, except in extraordinary situation, restrict speech on the basis of its content. Except, and the time, place, and manner regulation is an exception to that principle, except that the government may regulate speech in its time, place, or manner, when, where, and how. Even protected speech can be regulated in its time, place, and manner if the government jumps through the required hoops. But Justice Harlan in the Cohen case said, well, this law, the disturbing the peace law, is not targeted to a courthouse or a courtroom where there may be some justification for government controlling what's said there. This law applied any place. So it's not a place restriction at all, and it can be justified at all only on the ground that it was an improper manner of communicating the message. And then he pointed out that the content of Cohen's speech was not in an unprotected category, like obscenity, for example, which is not protected by the First Amendment at all. To be obscene, Justice Harlan said, the speech must be erotic, in some sense, sexually titillating. And Cohen's speech was not in that category. Nor did it fall in the category of fighting words, another category of speech that is completely unprotected by the First Amendment. We'll consider the fighting words exception when we get to the Jehovah's Witnesses cases where it was born. And then the most eloquent part, I think, of Justice Harlan's opinion is when he considers whether the state can excise the word fuck from all public discourse. in the marketplace of ideas, pointing out that the freedom to use this kind of vivid vulgarity may produce, the theory is at least, that freedom to use an emotionally charged word, like fuck, may produce a more capable citizenry and more perfect polity. This freedom promotes self-government in a democracy. And finally, this freedom promotes individual dignity and choice, individual autonomy, and self-expression. All of these are ideas, justifications, supporting the freedom of speech generally, that stem from Justice Louis Brandeis' opinion in Whitney versus California in 1927. And then, in addition to these affirmative reasons for allowing free speech, even rough, vulgar, inappropriate speech, like fuck the draft, in addition to the affirmative reasons for allowing it, there is the negative reason, which is that we don't trust government to make principled decisions on matters of taste. And he also points out that you can't ban particular words without risking the suppression of the ideas which those words are meant to protect. The government shouldn't have a list of unprotected epithets that it tries to enforce. And then Justice Harlan concludes that surely the state has no right to cleanse public debate to the point where it is grammatically palatable to the most squeamish among us, probably casting a side glance at Justice Berger and thing. And while this particular four-letter word being litigated here, and he didn't mince the words, he used the word in the FCC case that's pending before the court now, which involves the very same word. The last time it was in the court, Justice Scalia's opinion used the F word, which sort of signals where he's likely to come out. Anyway, our hero for the day, Harlan, says, while this particular four-letter word being litigated here is perhaps more distasteful than most others of its genre, it is nevertheless true that one man's vulgarity is another's lyric. And that's definitely the most quoted line that comes out of Cohen versus California. One man's vulgarity is another's lyric. Kelly? That it was what? No, it wasn't considered an improper manner. No, but that was maybe the state's better argument, was that it could restrict this speech because of the manner in which it's conveyed in a courthouse with this vulgar way. Yeah. Let's see. In the fighting words context, it's I'm going to punch you in the face kind of thing. You don't shut up. I'm going to punch you in the face. Here's the expressive conduct, I suppose. Cocking your fist and acting like you're about to do it. The words themselves don't require the conduct. Oh, well, there's two. Good question. 2 points. Neither one we've gotten to yet, but since you asked, you got it. Fighting words context has to be one-on-one, right in your face. That is, that the words used are highly likely to provoke immediate physical violent response. You say that and somebody get up in somebody's face and yell at them, they're likely to punch you out or punch somebody. That's the fighting words context. Then there's a principle of First Amendment law of much more general application, which is speech protective, that has nothing to do with fighting words, does apply to the Koran burning situation, which is that the audience, the probable reaction of the audience, a hostile reaction by the audience, does not deprive the speech of protection. You know, when the police get word that there's going to be a demonstration that is likely to offend the citizens of Skokie, Illinois, because at the time, back in the early 70s, it was largely a Jewish community with a great many Holocaust survivors, and the American Nazi Party decided to do a parade down the main street of Skokie. Clearly, that was going to infuriate the audience, the people who lived there. And yet, the court, didn't go to the Supreme Court, but the Court of Appeals decided that the probable hostile reaction of the audience does not deprive the speech full First Amendment protection, and that principle has been applied many times, including in the Supreme Court. You got to speak up so that everybody can hear you.
Can't a banner restriction on protected speech pretty much suppress the speech itself? Like if they said that yet a stronger showing communist flag was an improper method of conveying your message. If that symbolic speech is the most effective way of conveying your message, then does that act in practice as a content regulation?
Yeah, that's a helpful point and a very good question posted on forums. Thank you. And we'll see when we consider the next case, Clark, which is the seminal case on time, place, and manner restriction, that in order for the government to restrict speech, the regulation has to be content neutral. And your point is that if the only way, actually your point was the most effective way to get the message across is the way they're using, and the court decides that's an improper manner and therefore shuts down the speech, isn't it wrong? The test is not whether it's the most effective way of getting it across. The test is simply it has to be content neutral, the regulation, and there have to remain available alternative means of communicating the message. Otherwise, the government can't impose the time, place, and manner restriction. And I take it your situation would be one where there aren't any alternative channels. And if there aren't, then the government shouldn't be able to restrict it as a manner restriction. We'll do that one on Thursday, Clark, and then the Occupy material. So let's quit now and we'll pick it up on Thursday.